Good evening, good afternoon, good morning, everyone. It is my pleasure to welcome you all in this webinar series of CAFI, another episode of the series that we have been promoting. Today, we are going to be discussing document production in international arbitration with Nathan O'Malley. This is not only a very important and good topic to be discussed, but also it is our great pleasure to have Nathan O'Malley to be able to discuss it with us today. And of course, Professor O'Malley would need no introduction, but just to make the remark, he is a professor of law at the USC-Gould School of Law, a partner at Musick-Peeler, very well experienced practitioner in international arbitration, and author of many writings that have been our reference, especially in this field, and especially his book on rules of evidence in international arbitration that have been an inspiration for all of us. So thank you very much for being with us. Thank you for everyone that are with us today. We are live streaming in our YouTube channel, and I see that we have many colleagues and friends and students that are with us. Thank you very much. I would especially like to make the reference and to thank everyone that have been supporting us. All of our board at CAFI, the Arbitration Chamber of Federasul, our executive committee, and everyone that have been supporting. And our main goal at CAFI, and especially here with the webinar series that we are promoting, is to foster debate and to foster good practices in international arbitration. And I have the impression that document production and evidence production as a whole is one of the core features of and one of the main things that we have to be concerned once developing good practices in arbitration. So today, our idea is to discuss the rationale of this document production in international arbitration, and especially considering that arbitration, differently from mediation, negotiation, and other types of dispute resolution methods, here we have a final and binding decision and adjudicatory process where people are going to be attached to follow the final decisions. I guess maybe we have to be very careful about the boundaries, the possibilities. We are dealing with a private system of adjudication and not court. So today we are going to discuss this topic exactly to try to identify all of those possibilities. I would really much like to welcome also and thank Lucas Gavronski for being with us once again. And well, I'll give you the word to make your remarks and maybe just kick off our discussion here. Thank you very much.
Well, thank you so much. Very good morning, afternoon, or evening to you all. First and foremost, I'd like to really thank you, Nathan, for accepting our invitation. It's a great honor to have you. Also, I'd like to thank you, Gabriela, and all the members of the CAF, the board, and also the members of its executive group, which alongside with my colleague Andrea Bodanese, I coordinate. So thank you so much to you all for this opportunity. And last but not least, I would also like to acknowledge Marcio Vasconcelos, my dear friend and one of Nathan's associates back in LA. He played a key role in articulating this event. So thank you, Marcio, for that. And without further ado, if it's okay for everyone, I would just pass the word, to you, Nathan, so you can present your initial remarks. Also with a question already, which would be, what is the philosophy of document production in international arbitration? What is behind document production as a matter? Please.
Yeah, no, well, thank you, Lucas, and thank you to Gabriela as well for the introduction. As you mentioned, I am based here in Los Angeles, where I am a partner with Musick-Peeler and also serve on the adjunct faculty for the University of Southern California. So that makes me an adjunct professor there, and I enjoy the opportunity to teach on this topic of international arbitration on a regular basis, and I enjoy obviously discussions like this because it gives the opportunity to exchange ideas around these topics and learn from each other, as well as share ideas as to how things ought to be developing, and as they are developing. International arbitration is still a very fluid field where things are growing and developing and changing as time goes on, and we'll discuss some of those changes, I think, in today's discussion. So very excited to be here, and thank you again for inviting me. Regarding the philosophy behind international arbitration and document production, specifically in terms of the rules of evidence that govern this, we have to kind of cast our minds back a little bit to the earlier days of the development of international arbitration as a practice. And we go back to some of the early tribunals that were mixed claims tribunals and various interstate disputes that sort of paved the way for the practice of international arbitration as a way to resolve disputes that essentially crossed borders. In those instances, they were disputes involving political affairs and affairs between nations that also led to claims of citizens. And so they adopted procedural rules and practices that over time were integrated into the commercial arbitration field, in the sense that we borrowed a lot of these ideas. And over time, the early rules on arbitration really had no provision at all for document production and the exchange of evidence, and especially the idea and the concept that you could compel your adversary in the proceeding, or the opposing party in the proceeding, to turn over documents that were necessarily bad for their case. The ideas of early international arbitration were firmly rooted in the civil law tradition in some respects, and certainly it was in this way that courts who adopted procedures based upon civil law concepts, Napoleonic Code, but prior to that, the Roman law legal system. I spent many years practicing in one of those jurisdictions, and the idea that you could compel the other side to turn over a document to you was entirely novel to some of those systems. And in international arbitration, it similarly was the case that that whole system of document production hadn't really developed in the early stages. So around 1983, the International Bar Association developed a first set of guidelines for evidence, the taking of evidence. It was recognized that many of the established arbitration rules, which made only really vague references to sort of giving the arbitral tribunal power to compel evidence or to take evidence of one type or another, that those rules didn't have much to say on evidence. And as things developed, they decided, well, we need to come up with a sort of a set of rules or principles governing the taking of evidence. And that was first in 1983. Those first guidelines and those first rules said nothing about document production, except for the fact that potentially you could compel a party to turn over an original of a document, or to reveal or to produce a original of a document that had been referred to in another document. Very extraordinarily narrow situation where that could happen. Fast forward to about 1999, the IBA realized that those original rules hadn't been used very much, didn't really add very much value to what was being currently used, and started to revise them to come up with what is essentially the platform of rules that we now are dealing with today. And in that developmental process, they began to realize that the practice of international arbitration had developed over time such that it was recognized that in commercial proceedings or commercial arbitration disputes, that there was some scope to allow for parties to be able to request and obtain evidence from the opposing side. And the great fear, of course, and I don't want to take too long on this opening question, but it's kind of a lengthy question, but answer. But the great fear at that time, especially, and you saw articles and so many things being written that this was heralding the Americanization of international arbitration, was really put out there, because the idea that, as it said in the original 1999 or the first 1999 rules of the IBA rules on the taking of evidence, it said you could ask for a narrow category of documents. So not only could you ask for a single document, but you could ask for a category of documents. And this kind of, for a lot of practitioners very much rooted in the ideas of civil law procedure, this book sort of blew their mind. They say, you cannot do this. This is a problem. But the truth is, the 1999 subcommittee that developed these rules was only codifying what was already happening in practice. Arbitrations taking place in Europe and so forth were already doing these things. And so they basically put in some formal rules and guidelines around a practice that was already developing. And to that extent, it wasn't the Americanization of the process at all. If you've ever had the unfortunate circumstance of having to deal with American style discovery, as we call it, or document discovery, you realize, and then you've also done arbitration document production, you realize that they're the worlds apart in the sense that they are completely different in both their orientation and their focus and the intent. And so that's an important thing to remember, is that what has developed here over time is a truly international approach to this issue, with rules that are balanced between both civil and common law concepts on this question. And at the same time, is a process that's intended very much, in my view, and I think I tend to side with my civil law colleagues more than I do with my own sort of American or common law friends on this issue. But the rules very much are oriented more towards the filling of gaps in the evidentiary record, which is to say that the parties have prepared their case, they've brought their case, but in the course of their pleading of the case, it's become evident that there is some evidence that bears upon the outcome of this case that needs to be produced. And that's the intent of the process, is to allow a means and a mechanism for that to occur. That's different from the fishing expedition, where someone has no understanding of what their case is about and expects the other side to produce all their evidence to show them, to establish their case. So that's the approach that you find within the IBA rules and the general approach to document production and international arbitration. And so I would say those are the sort of philosophical underpinnings of how we got to where we are today.
Very good. Thank you very much. I guess it's quite interesting that we can see that this transnational characteristic of arbitration can be one of probably the main features of the development, but also the challenge, because we do know that the parties, even though the practice might have been developed and the rules might be developed to cope with the different backgrounds and cultures and so on, we still do have parties coming to arbitration and having possibly different backgrounds that might still pose a challenge. So I have possibly two questions here regarding that, especially considering that your practice was and your experience is not only regarding the American scenario, but you mentioned that you had a great part of your career also practicing in Europe and also having some experience here. So I have one question regarding that, which is if you still feel that even with the development of the practice and of the rules, those issues related to the backgrounds of the parties, especially if they come from civil law traditions or common law traditions, if they are still felt, if we do actually have a transnational in a different environment that would overcome totally the background of the parties. And also there is one thing that might be specifically impacting that, and we are feeling that, for example, here in Brazil now, maybe a little more than in the past, but also developing, which are concerns related to regulations, especially regarding data protection and how to deal and handle. You see, my point is, I know that, and I'm totally in favor of that idea that arbitration, international arbitration, should be seen as this transnational environment that maybe we will overcome the backgrounds, the legal rules that would come domestically. But my question is, can we actually do that, or should we do that? And do we do that in the practice of arbitration nowadays, especially considering your experience?
Well, I think, I mean, yes. I think that you definitely. So I'll take your question in two parts. First is that I think that when you have a proceeding, I mean, there's no doubt about it that when parties come to a proceeding, the tenor and the application of the standards that we're talking about today can be influenced by the background of both the arbitrator, the parties, and their lawyers. There's no doubt about that. That does affect. For instance, one of the standards that we talk about is in Rule 3 of the IBA rules, which says that you're supposed to produce a narrow category or request a narrow category of documents. And so the question is as we as lawyers, we know that we can take any descriptive term and we can argue over what it actually means. And for an American attorney that comes from a jurisdiction where document production is traditionally a massive undertaking with expansive and large amounts of documents being requested and taken in, narrow can mean, this, whereas civil law attorneys who may have no experience in this in their domestic context can think that narrow means this. So we can have those debates within the discussion of what the IBA rules require and what the standards are that ought to be applied. So there is some of that for sure. But I'm one of those people, and unfortunately, recently we've seen some pushback on this, I think. But I'm one of those people that does believe in the transnational practice of arbitration, and I believe that having spent the first 11 years of my career working in a jurisdiction which I was a civil law jurisdiction and was not based on my ideas. And seeing across Europe people of all backgrounds, Brazilians, Americans, Australians, English, working in Paris and Vienna and different places where you had people of all backgrounds working outside of their natural jurisdiction in this field, I can say that there certainly is a transnational approach to this. And the reason why I even wrote my book, quite frankly, to begin with, the first edition, was I got tired of having to continually go back again and again and again, explaining these transnational standards, and ultimately, and most of the times prevailing, because the arbitrators knew that they were true as well. And I wanted to, and others who have written, and there's so many things written about international arbitration, we couldn't fill a room. We'd need several rooms to fill all the books that are written on the topic. The idea is to try to establish these transnational norms. And so there's limits, I'd say, to what you can say a background of either a party or an arbitrator have in terms of the influence on the proceeding in most circumstances. The parties can always change the proceeding and agree to make it a very local one, in which case I argue that it's really not international arbitration anymore. But the question always is in our minds, what is international arbitration? And it is my firmly held belief that international arbitration is defined by the practices and approaches that are transnational. And those will vary. Those will have changes in different regions of the world to some extent or another. But what we look to establish, hopefully, is a bandwidth in which those variations still exist and are recognizable, such that parties can have, in principle, a procedure that they recognize in South America as much as they can in Asia, and with, of course, what we could say maybe flavors of the region being added to what is taking place, but nevertheless something that is recognizable in what's taking place. So I think the IBA rules establish that bandwidth. I think that the practices associated with them establish that bandwidth, but I think we have to acknowledge that there is regional flavors to this, backgrounds that can play a role, but at the same time, we do try to see that there is a transnational approach to these things in international arbitration.
Thank you. First, I forgot to tell our audience that they could make questions in the chat box in YouTube. So we'll try to address them as many as you can in the final part of this event. Okay. Moving on, Nathan, since you've referred these variations in the governing rules of document production, not just regarding the regional flavors, as you put it, but we now have a movement which is trying to present an alternative in regard to the IBA rules, the Prague rules. Is there really need? Is there a need for a second set of rules?
It's my opinion that there's not. It's my opinion that they are an unnecessary addition. Here, I guess I have three objections generally to the IBA rules, and briefly, the Prague rules, not the IBA rules, but the Prague rules. The first is that anything that you want to do under the Prague rules, you can do under the IBA rules. The IBA rules don't require you to have document production. They don't require the arbitrators to give a certain degree of document requests, approve a certain degree of document requests. They don't require the parties to wait till a certain point in the arbitration to do document production. You can do it earlier if you want, if that's what the tribunal wants to do. There's an enormous amount of flexibility within the IBA rules, and it's a wrong idea to think that they compel a certain type of outcome. They don't. They're used there to guide a proceeding that the parties and the arbitrators, to one extent or another, feel is necessary. So that's the first point. You don't need a second set of rules. The IBA rules are flexible enough that you can use them. And frankly, most of the time, the way the IBA rules are used is as guidelines, non-binding guidelines. The arbitrators refer to them and they say, this is a standard that we're going to apply, and but we're not going to necessarily follow every provision of the IBA rules. So that's the first thing. So there's no need for it, to my mind. The second point I would say about it is more of a functionality. I've gone through the Prague rules and I've looked at them quite closely, and their whole purpose is, as their formal title suggests, is to promote efficiency in international arbitration, and that means they want to adopt some things that they think that are going to help the process out and going to make it a little bit more efficient. But if you look at some of the approaches to it within the Prague rules, they are advertised as being a very empowering of the arbitrator. The arbitrator is empowered, as an example, in Rule 5.2, I think it is, to determine who's going to be heard as a witness. It doesn't matter. What the parties have produced, what witness statements have been submitted, whether they have been or not. We're going to determine who the witnesses are, and who's going to be heard in other words, who's going to be heard at the hearing. Well, obviously, if you want to cross-examine a witness, you'll be upset if the arbitrators decide we're going to accept the witness's witness statement and not allow him to be cross-examined at the hearing. So that's something that you're going to be upset by. But they say that that's going to create efficiency. But then 3 rules later, I think it is, or 4 rules later, I think it's around 5.7 or so, they say, but if a party wants to cross-examine a witness, the arbitral tribunal should allow them to. So what that tells me is that some of the things that they've tried to do to try to compel the efficiency, the rules themselves sort of recognize could violate due process. And so, so in the end, the effect is not what is advertised, which is that we're supposed to have this efficient proceeding. Another thing is they asked, one of the things that the PROG rule suggests is that at the first organizational hearing, the parties just kind of deal with document requests. That's a strange one if you want to produce efficiency, because one of the reasons we organize the document production in the way we do, which is generally after the case has been made in chief and the defense in chief has been made through a statement of defense, a statement of claim, with all the evidence that we intend to rely on, is it allows the arbitrators to see what the case is and then determine what is material and relevant, because they've seen the case. If you ask at the very first organizational hearing, I want documents, how is an arbitrator supposed to appropriately judge what is truly narrowly appropriate? They don't know what is the development of the case hasn't come on. And so, internally, the rules themselves I have problems with. And then the rules also sort of the PROG rules also sort of take a left turn and start talking about arbitrators serving as mediators and settlement. And so just a lot of things about the rules internally that I disagree with and I have problems with. They don't seem to me to be either internally consistent or at least helpful, and at the same time, not really oriented towards achieving the goals that they advertise. Finally, the last thing I'd say is, you, Gabrielle, Lucas, we could all sit down together, the 3 of us, and we could write up some great ideas about international arbitration, I'm sure. But the problem with that is would we consider those wonderful ideas that we have to be soft law instruments that are guidelines that reflect the universal approach to international arbitration? Well, we 3 might, but the question is, should anybody else? And I would suggest that despite the brilliance that I'm sure that would be put into that document that we created, they're not going to be authoritative. It's not an authoritative thing. And the IBA rules have developed in several iterations through an organization that's broadly based, reflecting common practices already underway and already subject to revision even now, as I understand. And they reflect practice. And that's what gives value to a set of guidelines. And so for those reasons, now all of this caveated, if we're sitting here 10 years from now and we do this again and you say, and we're talking about how the PROG rules have been used throughout the world and everyone is relying on them and they are great and wonderful and change the practice of arbitration, obviously I have to revise my point of view. But as we're standing here today, I just don't think that they're a necessary thing. I will say this, if you want to treat them as a set of suggestions for how people in a certain sector or a certain region of the world, primarily I think they were inspired from Eastern Europe and CIS countries experience, sure. Look at them as suggestions and proposals and ideas for how you can do things. But to put them on the sort of as a counterweight to the IBA rules of evidence, I don't think that that's probably an appropriate analysis.
Excellent. Thank you very much. Let me just reinforce, as Lucas mentioned before, that we are receiving the questions that are addressed in our YouTube page. Thank you very much for everyone that have been addressing. We are going to try to bring them to the discussion here. Let me, if I might, let me just make a special reference to Professor André Jobim de Azevedo that have been posing some concerns and questions, especially related to the data protection and all the document production things that we are discussing here. Professor André Jobim de Azevedo is our former president at CAF, so it's a great honor to have him and all the colleagues here. But now, especially concerning what you mentioned regarding the characteristic of soft law and not enforceability necessarily of either the IBA guidelines, the Prague rules, or any guidelines that we might use. If we, of course, we might and we should consider them like that. But on the other hand, arbitration is a very much flexible procedure, but with the basis of the consent of the parties and the agreement that they make between them. So my point here is either in the arbitration clause or as to reference of arbitration chambers rules, or even to any of those guidelines, we might have the necessity to fulfill some particular rules that the parties have chosen between them to be the ones to conduct the arbitration, right? So if they explicitly, and if they have the consent, and if they make reference to, for example, rules of a particular arbitration chamber, like the Chamber of Federasul, for example, I guess we have to consider them bound to those specific rules. So my question here is, do you see in your practice, and as having been practicing in most of the main chambers that we have around the world, do you see differences of rules that have been specifically applied in the chamber's rules and in the choice of the parties as to refer to those rules?
Well, there are yes and no. Most chambers in the rules will affirm the right of the arbitrator to order the parties to produce evidence generally, or facts, or produce evidence of any kind, and that you see those kind of broad statements such as in the ICC rules 25.6 or the Institutional Article Rules 27.3, where there's just kind of a broad remit given to the arbitrators to order, and the order evidence to be produced or turned over or to be given to the tribunal in one form or another. And so those rules there, provide a common platform where it is well accepted now in international arbitration that arbitrators have this right. They have this authority, and typically this authority is exercised in response to the application by one side or another that a document be produced to them. So those commonalities tend to exist. Then you start to see other changes in the rules that can be a little bit different. And you have the ICDR rules as an example in Article 21, and where there's some very specific statements made about what kind of evidentiary documents should be produced. And in actual fact, those statements in the ICDR rules reflect very much the standards found in the IBA rules. So the ICDR rules, I think, make sure I say this correctly, the International Center for Dispute Resolution, the AAA's, the American Arbitration Association's international arm, their rules reflect what you find in the IBA rules as on evidence. So in that sense, we see a commonality between the IBA rules, which are more just guidelines used by parties, incorporated and used in the proceedings next to the arbitration rules. You see them being incorporated into what maybe we could consider to be the hard rules, the rules that have been selected by the parties to govern their proceeding. And so you see that as an example with the International Center for Dispute Resolution. Also there in the ICDR rules, you also see in Article 22, some guidance on privilege issues, attorney-client privilege and other kinds. And those standards there, again, very much reflect what is found within the IBA rules. So you see some sets of rules that go above and beyond sort of essentially just authorizing the arbitrators to order evidence to be turned over. With regard to, do we want to talk about data protection now, or should we wait until a specific question on that?
No, feel free. I mean, I was just bringing up the questions and the concerns, and I guess overall our main topic here is the boundaries to whether we can the parties can establish, the arbitration chambers can establish that within their particular rules, and if we have those boundaries, that could be considered either in privileges, attorney-client, or data protection, and etc. So feel free to make your remarks. Thank you very much.
No, sure. Well, let me just say that the institution that is going to probably, or the body that is going to be most interested in implementing data protection protocols is the arbitral institutions, and you see that the AAA, as an example, again, the ICDR has developed a very extensive set of data protocols that the arbitrators and the parties are asked to follow in order to protect evidence. Those protocols, specific or otherwise, build upon a long tradition that's reflected within the IBA rules, Article 9, which allows for arbitrators to fashion rules on confidentiality, to allow for confidential documents to be used, but then only for the purpose in the arbitration. And next to that, some practitioners such as Michael Lang, QC or SE of Singapore, has developed even more extensive, which I use as an appendix in my book, even more extensive guidelines for how documentation that's been produced in a confidential way in consideration of things like data protection requirements and this kind of thing can be implemented. So arbitration's flexibility allows for ad hoc solutions to be developed by tribunals to allow for the necessary sensitivity to be observed. But at the same time, institutions themselves are giving out guidelines on this and are allowing, developing these guidelines for the purposes of allowing parties to participate in the process with sensitive data and information, while at the same time observing any obligations or regulations that pertain to it.
Oh, thank you. Well, getting back to arbitration rules from institutions around the world, is there a practice, not just regarding data protection, but to document protection in general, that you believe should be adopted if it is not already adopted in those rules? And also I'd like to hear about you, if you do believe that there are some convenient provisions that should be inserted when a practitioner is drafting an arbitration clause regarding document production.
My general feeling about evidentiary procedures in arbitration rules is that that I would prefer that our arbitration institutions, to the most part, leave those issues to the arbitrators to decide and follow, especially in reference to the IBA rules. I think that the development of the IBA rules is particularly positive is because it can be used in every arbitration just about, no matter what the institution is that's involved. And that helps us to develop a standardization of practice that allows us to anticipate the kind of things that are going to happen. Of course, all of this is persuasive. The parties can always make changes. They can always alter what they want to do, and the arbitrators and the council can maybe sit together and fashion specific procedural order that they want to follow. However, if the arbitral institutions each start adopting their own specific rules on the taking of evidence, I'm reticent. I'm a little bit hesitant to support that, because it's helpful that if I do an LCIA arbitration, or if I do a SIAC arbitration, or I do an ICC arbitration, that I can refer the arbitrators back to a very the same standards, and say, look, these are the standards that we're all using. They're not binding, but nevertheless, they are persuasive, and we would like you to look at them and help us in fashioning this procedure by adopting an approach that's consistent with what we see there. So that would be my general view. On the ICDR rules, they do have very specific rules, but I think that has a little bit to do, as much as anything, with restraining the American tendencies to want to follow American procedure and allow for wide-ranging discovery and depositions and everything else. And so they've kind of put it into their rules very specifically, because they want arbitrators in the United States to look to the international standards as opposed to following American standards. So that's why I think you see it a little bit more there. So I guess that would be my general view on it.
Thank you. Thank you very much. I see that we have many questions here being posed in our chat regarding the limits and the possibilities of the arbitral tribunal imposing document production, especially when the party or one of the parties do not agree to do so. So in your point of view, my question is, in your point of view, when and how do you think that the arbitral tribunal could or should impel a party to produce that evidence if they are unwilling to do so? And especially, what are considering that arbitration is about the consent of the parties that are involved in that particular procedure, and I totally agree that the parties and the arbitrators, they can tailor the dispute and the limits and the boundaries, but then we have another particular issue that many people have addressed here in our chat, and I maybe can suppose that because just to put that in context, we do have an arbitration competition going on now in Brazil, the national arbitration competition, and the case has a lot to do with the limits, the boundaries of that document production, especially in the case that the document is not in possession of the parties that are bound to that arbitration procedure. So can we consider arbitrators to be empowered to request or order the document production that is on the hands of people differently from the ones that are involved in that procedure? And would it make a difference, for example, if the party that is in the person or the company that is in possession of the document is part of the same economic group, or somehow can be not necessarily bound to the arbitration clause, but connected to all the facts and circumstances that are attached?
Yeah, so let me address that very specifically, that question. You know, the rules themselves contain a standard, which is that when a party seeks document requests, they, under Article 3, they need to establish, under the IBA rules, Article 3.3, they need to establish that the document is in the possession, custody, or control of the opposing party. And so the question with economic units, where you have subsidiaries and parent companies and all operating, maybe you see this all the time in the context of construction disputes, as an example. The question that the temptation may be from one side who doesn't like a document request to say, I'm sorry, technically it's in our safe in the corporate headquarters in England, and we're unable in this arbitration to produce it here. So the traditional point of view of this is to establish is to consider that standard custody, control, or possession in a fairly broad sense, which is to say the party making the request has to provide some prima facie evidence that they think that there's a reasonable belief that party has the ability to obtain the document. And I think if you were able to show that the document was part of a company that was part of a group of companies, you would be able to demonstrate that. You would be able to say, well, look, there's a reasonable basis for us to ask them to produce it. It's held by their sister company, their maybe their parent company, whatever, and they should be able to call within their group of companies and obtain the access to that evidence. Once the party that's made the request has produced some evidence that this document is generally available, it's up for the other side then to demonstrate why it would not be. And I can tell you that the evidence, as I cite in my book, that the cases that have considered this question, arbitrators have been fairly practical in their point of view on this. While we all accept the entity theory that companies are different companies, they have also said, yes, but you have you're under common ownership, or you're part of the same group, and it should be something reasonable that you are able to obtain this document. And so it's that possession, custody, or control standard that really becomes the issue when you're looking at that question. And so I would say that the burden really shifts to the party that is claiming that this internal group of companies that exist, somehow they're prohibited from obtaining this evidence. I think it becomes their burden to demonstrate why, despite their strong and close connections as companies to each other, despite the fact that they're part of the same economic relationship and group, despite the fact that they're working together consistently on a regular basis, despite the fact that there are officers and owners that that are common between them, despite all of this, there's some reason why this document should be considered outside of their potential possession, custody, or control. And if they can show that, and there's some basis for that, then sure, arbitrators would be willing to potentially accept that explanation. But if a company says, they are very formalistic and say, we don't want to go call our sister company and ask for the document, the arbitrators are then left with a decision as to whether or not they should draw an inference against that party, which is to say, determine whether or not the evidence that would be that has been the explanation, what that evidence is intended to prove, would in fact prove the point, and they can draw a negative inference against a party. They also, under the IBA rules, have the option of if they feel that they're just being uncooperative, they have the option of ruling that they are to bear the costs of the arbitration, at least in regard to the document production issues. And so that is also in the IBA rules. So they have those tools they can use to sort of compel compliance by the party that's reticent to comply and turn over a document.
Okay. Following on this same question, you've mentioned that in those extreme circumstances, an arbitral tribunal would be forced to draw a negative inference from a reluctant board in producing a document, even though the arbitral tribunal has already issued an order in this sense. But are there cases in which, even if the arbitral tribunal orders the production of some evidence, a negative inference would not be an adequate measure to deal with a party that has not complied with the tribunal's order?
Yeah, when the inference that's being requested to be drawn is one that's inconsistent with other evidence, tribunals will often say, yes, they should have turned over the evidence. Yes, we would have liked to have seen it. But what you're asking us to draw as the inference from their failure to do it is inconsistent with other things that we know about in the evidentiary file. And so therefore, it wouldn't be appropriate for us to draw that inference. So typically speaking, if you can establish that the party knew that they had an obligation to preserve and produce that document, that the inference that's being drawn or being requested to be drawn is one that's consistent with other evidence, that there is some maybe prima facie evidence already in existence that inference is appropriate. If you generally look to those guidelines and those things are true, then tribunals typically feel that they can draw the inference. But if the inference that's being requested is something entirely inconsistent with the evidence or inappropriate for a number of reasons, then they don't have to do that.
Thank you very much. We are almost approaching our finishing time. Of course, this is a subject matter that we could, and I wish we could keep going, and I wish we can in the future maybe have the opportunity to discuss it even further, maybe in Los Angeles or in Brazil. You're always welcome to come here. But since we are almost approaching our time, I would leave it open in this ending for maybe some final remarks or any additional comments if you would like to do so. Again, thanking you very much, Nathan, for being here. Thanking everyone that is with us on YouTube and everyone that has given support, because this is all what it is about, having all our arbitration community, not only in Brazil, but one of the good things about the pandemic is that we can discuss it and be cross borders with a little more efficiency. So I'll just leave it open now if you would like to make final remarks, maybe future perspectives or any issues that you think that maybe should be in our spotlight for the future.
Well, I appreciate the opportunity to be here today. I'm glad that we had at least some questions or issues come up through the course of the discussion today that were useful for me to try to address. Just generally speaking, I think that one of the things I believe about the question always comes to mind: what is an international arbitration lawyer? So who is someone who knows, who can call themselves an international arbitration lawyer? And I certainly think that one of the characteristics of someone who is a specialist in this field is to understand these evidentiary practices and to understand how these things work. And over the years, these were practices that sort of everybody knew, but nobody ever wrote about because it just kind of happened. And so in the last decade or so, we have seen a lot of writing on different aspects of procedure that are very helpful for initiating new entrants into the field. And so I think that both the fact that you have a moot competition that addresses this issue, the fact that you're doing webinars like these and bringing in people to understand how these standards work and how, we could do a whole webinar on what it means, what does it mean to produce a document that is relevant to the case and material to its outcome? What are these different standards in Article 3 and otherwise, this objections Article 9, what do they mean? Those are really useful things because they are the nuts and bolts of practice, and they inform strategic decisions. I had a great discussion like this in Perth, Australia just a few months ago, where we sat down with a group of practitioners there and discussed what the things that they are seeing happen. And we're talking about the common and same standards. And so it's a really positive thing to know that organizations like your own are promoting and developing this and also that there's interest in these things, because I think this helps promote the practice of international arbitration. The way forward, very difficult to say what's going to happen. I mean, the pandemic has shown us that predictions are useless because we have no idea what's going to happen tomorrow and no idea what will happen next week. But if everything were to say come back to a normal posture and we were able to see the way forward in terms of continuing the development of the world economy, then arbitration will continue to thrive, I think. And I think it will continue to present the way and the solution for the thorny issue of having to resolve disputes that are cross-border in nature. So I applaud you. I'm really happy to know that there's interest in this issue, and always willing to discuss it with individuals or practitioners. I work with arbitrators from all over the world all the time, both as arbitrator and counsel. And I say it's always great to meet people from different parts of the world that we can discuss some of these things and have a common understanding. So it's wonderful that you're doing this, and thank you for having me.
Well, thank you so much, Nathan. Well, we've received a lot of questions from our audience. We tried to refer them as many as we could in this time. There's only one final question that I believe it is important for you to address, which would be where or how Brazilian students could access your book that we've referred more than once. And please.
So most law libraries have it. So if you obviously, and a lot of law firms have it. I've had students come to law firms and ask to borrow their version of it. Obviously you can buy it, but if you're a student, maybe you don't want to spend that much money on a book. You've got a lot of other things to worry about than buying books about evidence and international arbitration. So I mean, the most of the things that I can tell you are the law libraries tend to have it. Law firms tend to have it. It's available online, obviously, if you want to purchase it there, and that's probably the best advice I can give on that. And to all you students that are involved in moots, and because every year the Viz moot, the one in Vienna as an example, if it has an evidentiary question, I inevitably know it because I start to get requests and questions that get sent to me. Those moots are doing a great job by trying to get kids to learn and students to learn those things, and young practitioners to get involved in those things. I'm always trying to be responsive to those issues when they come up as well. So.
Thank you very much for your generosity, not only in the references, but also for being with us today and exchanging so much. Hopefully we can meet again soon. Thank you for everyone that have been with us today. Thank you, Lucas, also. And well, I hope to see you again soon.
Thank you. Been a pleasure.
Thank you. Pleasure. Bye-bye.
Thank you, everyone. Bye-bye.
Bye.